Thank you very much. Good afternoon, ladies and gentlemen. First of all, I must apologize for being late this afternoon. Thanks for your patience. Thanks for accommodating the program so that I can still speak to you this afternoon about quite an important a major reform of the patent system in the European Union. You see it here on the title slide, the new European patent with unitary effect, and the creation of a unified patent court covering an international court for patent matters in Europe. Before I go into the details of these two projects, perhaps a very brief word of introduction about the existing patent system and why exactly a reform is actually needed. Three routes exist today to obtain a patent in the different countries. This morning you had, I think, a presentation by an official by the Estonian Patent Office. That's the left column of the slide. You had also a representative from the World Intellectual Property Office. That's the international route on the right side. So I can focus on the middle row, the European route to obtain patent protection. I do that with pleasure. I work for the European Patent Office. I've worked there for 15 years now. I'm Danish originally, but 15 years in Munich at the EPO has sort of made me a European. The idea behind this European Patent Office is that one single European administration will examine, will first receive, then search, then examine a European patent application and eventually grant one European patent, which may then give patent protection in up to a maximum of 38 states. I have a map right away here with all these 38 states. It's more than the European Union. The 28 European Union member states are members of the European Patent Office, but you see also Norway, Iceland, Switzerland, Turkey are members of this organization, and again, by filing a European patent application either directly at the EPO or via the Estonian Patent Office, you can obtain a European patent which may then take effect in all these countries. This European Patent Office has been a huge success. Look at the number of filings, direct European patent applications and patent applications coming in via the PCT system. It's an awful lot. We have reached by now 40 years after the beginning of the European Patent Office. We need a lot of staff to deal with all these applications. 800 formalities officers check the application when they arrive at the EPO. That's the filing, the formalities check at the beginning. Then our technically qualified engineers, we call them examiners, look into the substance of the European patent application. That's the search and examination phase. And in the end, if the patentability requirements under the European Patent Convention are satisfied, then a European patent is granted, and as mentioned, it may take effect in up to 38 of our contracting states. After grant, you see the possibility to file an opposition. Any third party may file an opposition at the EPO against a European patent. We have 3,000 of these oppositions each year. And also a judicial body in the EPO, that's the boards of appeal, to check the work of the examiners of the administrative work of the EPO. If you get a European patent, it will look like this. It's a piece of paper. but an important piece of paper giving you an exclusive right to prevent a third party to use the invention described in this document, in the claims and the description and the drawings of the European patent. We grant some 50,000 to 60,000 European patents each year. You see here the origin of this application. Almost half of them come from outside Europe, the United States, of course, the Japan traditionally. China is still 2%, but of course rising. Let's see if it continues. European on the right side, Germany first, a huge patenting country, and then the others, and I think it's also the Baltic states feature, of course, apply for patents at the EPO and receive European patents each year. Now, I repeat myself, all this is a wonderful success, but I came here to speak about the reform of the European patent system, because there are a couple of problems, in particular in the life of the European patent after grant. After the EPO after the European Patent Office has granted the European patent, patent proprietors have a number of problems. All these problems come from the fact that the European patent, after grant, becomes a sort of national patent in the different countries. National patents means national requirements in each and every of these 38 states. These requirements may be translations that have to be filed in the different states to actually obtain patent protection. Patent proprietors will have to pay annual fees each year in each and every state to maintain the European patent in force. This is administration, it's costly, it's a problem for the users of the patent system. First problem, costs. Second problem, enforcement. If a patent proprietor wants to sue an alleged infringer for infringement of the patent, he has to go to the different national courts in each and every states, each and every of these 38 states, if he wants to enforce the patent in all the countries. Also, this is costly. You need to hire a lawyer in every state. You need experts. You need to pay court fees. It's, again, a lot of money. And there is also the risk that the different national courts reach diverging different decisions on the same patent. So one European patent is revoked in the United Kingdom before the English court. The German court, by contrast, maintained the European patent as granted. And all these differences are bad for business. They don't know, do I have a patent or do I no longer have a patent? It's a problem in practice for patent proprietors. To solve these problems, a major reform of the existing European patent system, a project of the European Union, of 25 member states of the European Union. So we are in Brussels, where the member states adopt regulations, EU regulation, one regulation creating a new European patent with unitary effect. It was adopted 2 years ago and will enter into force probably within the next 12 to 15 months. A second regulation about the translation arrangements for this new European patent with unitary effect. Second element of the project, an international agreement, a treaty, creating one common supranational court dealing with patent litigation. Very briefly, to start with, what is this new European patent with unitary effect? Let's call it also unitary patent, to do it shortly. It's a new European IP right created by regulation of the European Union. The special thing about the new unitary patent is that it's based on a European patent granted by the European Patent Office. So the procedure before grant, filing, search, examination, remains exactly the same as it is today. What is new is that after grant of the European patent, the patent proprietor may request to the EPO that a unitary effect be given to the European patent. And this unitary effect will then apply in 25 EU member states. Very simple requirements. The European patent must have been granted for all the 25 member states. A few formalities to be complied with, but here nothing difficult. It's not substantive examination of patentability. It is really formalities which have to be complied with. Now you may wonder, the EU is 28 member states. Why is this only for 25 member states? And well, I have again another map here where you see that one important country to the southwest is not participating in this project. Also Croatia is not participating, not yet, I would say. An important news is that Italy, which did not participate until July, has now decided to participate in this new unitary patent. There's a lot of politics behind this. Spain does not like the language arrangement for this new unitary patent, so they will not participate for the time being. Here you recognize, just to recap, you recognize in gray the existing procedure to obtain a European patent. It remains the same grant procedure as we have it today for obtaining a European patent. What is new is that the patent proprietor, once he has received information about the grant of a European patent, may ask that unitary effect be given to the European patent for the 25, or with Italy it would be 26 member states participating in this project. Summarized the key features of the new unitary patent. No fee. First of all, it's important. Patent offices are good at charging fees. I should say perhaps here, there are fees for obtaining the European patent. In total, you have to pay a fee when you file the application, when you ask for the search, and when the patent is granted. In total, it would be, for a European patent, it would be around 4,000 euro in fees to be paid to the EPO. And in addition to that, you would need, or it's highly recommended, that you ask for the assistance of a European patent attorney. I think there are a bit more than 30 European patent attorneys in Estonia, so you have locally an advisor which can help you. So the cost for obtaining a European patent in total could be around 10,000 euros. If you now want a unitary patent, once you have received the European patent, there is no additional fee. First good news. Second good news, after a 6-year transitional period, there will be no translation requirements anymore. So your patent will take effect in all the 25 or 26 member states without any translation requirements. You don't need to file anymore in different countries translation of the patent or of the patent claims in the different languages. This is possible due to a wonderful technological means called Patent Translate. That's automatic computer-generated machine translation, which translates 24 hours a day instantly from and to a lot of different languages all these patent documents. It's available today online, free of charge. We have more than 20,000 requests daily for these machine translations handled by our computers. And it's available also to and from English and in Estonian, in all the languages of the member states participating in this project. Plus Chinese, Japanese, Russian, Korean. But I don't need to explain that this is, of course, the future for these translations, in particular because they are for information only. If you need, let's call it a legal translation of a patent document, then it's advisable to go to a specialist, either a patent attorney or a professional translator, so that the exact wording of each word in the claims are correct. If you only need information about the general content about a patent application or a European patent, then go to the online patent translation scheme. It's very easy to use. Third, let's call it advantage of the new unitary patent, a centralized register. Today we have a situation where each national patent office has its own national register. So a licensee, for instance, or if the patent is transferred to another person, you need to register this in the national register. It costs money. You may need a representative. For the new unitary patent, there will be one single register maintained centrally by the EPO. So also here, less red tape for patent proprietors. Renewal fees, we come to how much what the level of these fees are in a second. Already now one advantage, instead of paying national renewal fees to the different patent offices in the countries where you want the European patent to continue to have effect, for the unitary patent, it would be possible to pay the annual fee centrally to the EPO. Also here, a practical advantage for users. Uniform protection, of course, the right conferred by the patent, the limitations are no longer dealt with by national law in different countries, but are now included in this international agreement created the new court. I will come to that in the last 5 minutes. A unitary legal regime also important in practice when you conclude a license agreement. It's not the national law of the different countries which will apply. It's one legal regime. I feel I should mention here one word more about the language arrangement. It's a special possibility for SMEs, universities, NGOs active, located in the European Union to obtain a compensation of their translation costs when they obtain a unitary patent. When you file the application at the EPO, you can file it in Estonian, but you will then have to translate it into English, usually, or German or French. And the costs of these translations into English can be reimbursed up to a maximum of 500 euros if you later ask for a unitary patent. So here are special schemes to support SMEs introduced by in the unitary patent regulation. The renewal fees, now it's about money, so there has been a lot of discussion between the member states to set the level of the renewal fees for the unitary patent. Users wanted these renewal fees to be low, of course. The patent offices wanted them to be rather high, so that because the reason is that the European Patent Office is paying some of the cost of the granting procedure with the income from the renewal fee in the later life of the patent. I jumped straight away to the schedule of renewal fees. You see, it starts rather low. So this is the level of the single annual renewal fee